a
This
moment.
inspector?
Please, my lord, the very same inspector, my lord, he barges into the property and everything, my lord, he comes with 100 people into my property with
Dura.
JCB. Yes, my lord.
The policemen have started using JCB also, is it? How did you arrest him? And why did you arrest him? Stop this police Raj. Were there instructions from any of your superiors to arrest? I will direct departmental inquiry against the entire station.
I'll keep them present, my lord.
Not necessary, sir. They will be watching anyway.
Mistake has happened, my lord. My officer should not.
No, sir. If mistake has happened, they better well pay for that mistake. Cost of rupees from his salary, sir. Not from his pocket it has to go, not from the state exchequer. Cost of such illegal arrest is quantified at 3 lakhs. Him joke arrest madadu. Why I am asking this is not, he is a scapegoat. Somebody else is controlling him, somebody else has directed him to arrest this man. Nobody will arrest you, madam, now. Don't worry. Whitefield Police Station will not arrest you. Definitely not. They dare not arrest.
Cost, maybe.
No, sir. Costs and departmental inquiry, eradu.
Departmental.
No, sir. No, when do the policeman...
No, the mistake, what happens, my lord, I understand, my lord. I am not in any way justifying. Ultimately, my lord, unnecessarily the same in hierarchy, they unnecessarily blemish the person.
That's why entire hierarchy have now mulcted it, sir. Not only this man.
Departmental inquiry.
Whoever, ACP and DCP. Adu DCP ಹೇಳಿರೋದಕ್ಕೆ ಆಗಿರೋದು ಇವೆಲ್ಲ. Absolutely, no doubt about it.
Departmental inquiry and you're not target.
He is made a scapegoat now. It is the DCP and the ACP are behind this.
Actually, the departmental inquiry will last. Ultimately, he will be targeted. He is the person.
ಯಾಕೆ ಮಾಡಬೇಕಾಗಿತ್ತು? ಏನ್ DCP ಹೇಳಿದ ತಕ್ಷಣ ಏನ್ ಬೇಕಾದ್ರೆ ಮಾಡ್ತೀರಾ? ಕಾನೂನು ಗೊತ್ತಿಲ್ಲ ನಿಮ್ಗೆ? Yes.
The departmental inquiry.
That will see later. Cost ಅಂತೂ 100%. ನೀವೇನ್ ಡಿ ಬೇಕು ಅಂತ ಹೇಳ್ತಿದ್ದೀರಾ, ಕಾಸ್ಟ್ ಬೇಕು ಅಂತ ಹೇಳ್ತಿದ್ದೀರಾ?
ನಾನು ಎರಡೂ ಬೇಡ.
ಎರಡೂ ಬೇಡ, ಇಂಪಾಸಿಬಲ್. ಎರಡೂ ಬೇಡ ಅಂದಂದೇನೆ ಇಲ್ಲಿವರೆಗೆ ನಾನು ಮಾಡಿಲ್ಲ. ಆ ಇನ್ನೊಂದು ಕೇಸಲ್ಲಿ ಅಕ್ಯೂಸ್ ನಂಬರ್ 1 ಸಿಕ್ಕಿಲ್ಲ ಅನ್ಬಿಟ್ಟು ಮನೇಲಿ ಅಕ್ಯೂಸ್ ನಂಬರ್ 2 ಇದೆ ಅಂತ ಕರ್ಕೊಂಡೋಗಿ ಅರೆಸ್ಟ್ ಮಾಡಿದ್ದೀರಾ. What is this?
No, DG has taken action on that.
What action? ಅಲ್ಲ, ಅಕ್ಯೂಸ್ ನಂಬರ್ 1 ಕಾಣೆ ಆಗಿದ್ದಾನೆ, 2 ಮನೇಲಿ ಇದೆ, ಬಾಯಲ್ಲಿ ಕರ್ಕೊಂಡೋಗಿ ಅರೆಸ್ಟ್ ಮಾಡೋದು. What is this?
No, DG has taken action on that.
Is this the way policemen behave here?
Not a.
ಇನ್ಯಾವ ಇನ್ಫ್ಲೂಯೆನ್ಷಿಯಲ್ ವೈಫ್, ಹಸ್ಬೆಂಡ್ ತುಂಬಾ ತೊಂದರೆ ಕೊಡ್ತಾ ಇದ್ದಾನೆ, ಅರೆಸ್ಟ್. This is how policemen are used. Law is misused because of the connivance with the policeman.
Your Lordship's order must be circulated to all police stations, so that this is not an effect only on Whitefield, but it should go across.
Whitefield alwa ella kade white wash agutte. Yes.
The one clarification, my lord, Lordship, make it. Since the offence is 10 years, they should not have issued a notice unless.
Offence ಯಾವುದು? 340.
338.
ಅಲ್ಲ, 338.
They should not have issued a notice, my lord. That's.
But I will clarify. Allah,
He should not.
that is accused, sir. Accused number 1, man. Accused number 2 is admittedly a witness.
No, I'm not on that.
Where is 338 coming against him?
Tomorrow they will take this judgment and say even for 338 you have to issue a rectification.
No. Well, that I will clarify.
Lordship clarify.
Yes. Swamini madam, accused number 1 ಕೊಡಲ್ಲ ನಾನು. ನೀವೇನ್ ಮೂವ್ ಮಾಡಿದ್ರು ಅಷ್ಟೇನೆ. Let accused number 1 be investigated into. Don't take advantage of this for accused number 1. ಅದು ನಿಮಗೆ ಸಂಬಂಧ madam. You and the complainant, whatever you want, you do. Don't drag this witness into the proceedings. Nobody will arrest you, madam, now. Don't worry. Whitefield Police Station will not arrest you. Definitely not. They dare not arrest you. ಅವ್ರಿಗೂ 35(3) ಕೊಟ್ಟಿದ್ದಾರಾ? ಅಕ್ಯೂಸ್ ನಂಬರ್ 1 ಗೂ? ಅಲ್ಲ, ಅವ್ರನ್ನ ಮಾತ್ರ ಬಿಟ್ಬಿಟ್ಟಿದ್ದೀರಾ?
No, my lord.
ಎಲ್ಲಿ ಅಬ್ಸ್ಕಾಂಡಿಂಗ್ ಆಗಿದ್ದೀರಾ?
My lord, because there is a threat of arrest, my lord.
So you are not to be seen, is it? That's why this witness has been taken now.
No, my lord. One humble submission, if your lordship.
Police has now come up with a novel idea. If accused number 1 is missing, accused number 2, 3, 4, you arrest.
Atrocities of the police inspector, my lord, your lordship, have taken my petition for a
This
moment.
inspector?
Please, my lord, the very same inspector, my lord, he barges into the property and everything, my lord, he comes with 100 people into my property with
Dura.
JCB. Yes, my lords.
Hey,
And the police officers, the DCP and everything, I come before this
The
honorable
policemen have started using JCB also, is it?
My lords,
So JCB lo ಹೋಗ್ತೀರಾ?
my lords, they have, there is
ಇಲ್ಲ,
a
ಜೀಪ್ ಅಲ್ಲಿ ಹೋಗ್ತೀರಾ,
videographer.
JCB lo ಹೋಗ್ತೀರಾ? ಬಿಟ್ರೆ ಅದು ಮಾಡ್ತೀರಾ?
Does the Supreme Court also witnessed the atrocities which they came into with the JCPs, my lords? And also the Supreme Court has taken a note that this is not a kind of an action where a law and order has to be protected.
No, I think.
No, but I will show it in the findings of this honorable court, my lords.
there was an incident where the firing happened, police have gone there.
Because
This court
that
has called, I
also
think
is
your lordship
taken
has
note
called.
of this
No,
honorable
that
court,
accused
my
number,
lords.
accused number one, I am not interfering. Accused number two is admittedly a witness. You, one ಸಿಕ್ಕಿಲ್ಲ ಅಂದ್ಬಿಟ್ಟು two ನ ಎತ್ಕೊಂಡು ಹೋಗೋದು. This
And
should
also-
stop. ಎಲ್ಲಾ ಕೇಸಲ್ಲಿ ಹಂಗೆ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. Accused number one is absconding, accused number two is at home, take him.
My lords, it's
And
not
this is the case, my lord. I
my
think
lords,
your
there
lordship
is a
has called the
contempt
ACP last
petition,
time.
my lords.
The JCB was.
One humble
ACP
submission, my lord. There is a contempt petition.
ಯಾವ್ದು
because
ಅದು? ರವಿಶಂಕರ್
initiated,
appear ಆಗಿದ್ರು
framing
ಅದೆಲ್ಲ?
of charges also
I think-
was initiated. This honorable court, my
No,
lords, when it
GMCPC I think I agree.
Correct.
These, my lord, this honorable court in
The
GMCPC
ACP was
also, my
asked to
lords,
come,
had
ACP has
also
made a
held
submission.
that police has to implement the order, but they never do, my lords. I give hundreds of representations. Your lordship may see, my lords, even your lordship in another petition where I am the complainant against the complainant, my lords. Your lordship has also held the Whitefield Police to give an inquiry. I have placed that in before this honorable court, my lords, in my red petition. Till today also, my lords, there is no
Speak
inquiry
better,
report.
wait.
No,
Let
is
it,
the-
let it come
It is the
tomorrow.
same case, my lord, where your
I
lordship has
liberty
called
may be
an ACP.
protected.
Yeah,
I
nothing
will-
will happen,
my
madam.
lord,
Nobody will
and that's
arrest
in
you
the
now.
investigation.
Nobody will arrest you now. Yes.
The
Because
same
that
case
let
your
it be
lordship has
on
called.
record.
No, no,
my
no, no,
lords.
nothing. Yes.
The same case ACP has called, my lord.
Because let
There
a
was a shooting
coercive
happened.
steps need not be
Because of the
taken, my
shooting-
lords.
Oh, this, I had
Yes,
called
my
this
lord.
ACP to
Yes.
the
Yes, my lord.
court.
Yes, my lord.
That lady came to
Yes,
the court
my
and
lord.
justified
Yes,
why they had to interfere. ಅದೇ ಕೇಸ್ ಆಯ್ತು.
Yes, my lord.
But why did you take the witness? Accused number two ಮುಟ್ಟೋ ಅವಶ್ಯಕತೆ ಇರಲಿಲ್ಲ.
There seems to be history of the
What-
petitioner.
maybe,
I
sir,
can't
maybe.
justify, my lord. I can't justify.
Maybe.
I can't justify.
Once you have,
That's what happens, my lord. My
with impunity, if you have violated law,
I can't
you will
justify,
face
my
it.
lord.
Yes.
These are
My
same
lords, let
continuation of the
not
same
a
issue, my lord,
coercive
where
step, my lords, be taken. I filed a PCR in the year 2008, my lords. He sleeps for 16 years and no investigation is considered. When I stepped into the court and asked for an investigation report, then the notice is issued to the complainant. Till then, my lords, they don't even take, and
No,
this
no, we'll
honorable
see.
court.
We'll answer everything here.
Please, my lord,
Yes,
let my liberty may be protected, my
Nothing
lord,
will
not a
happen, madam. ನಾಳೆ ಬೆಳಗ್ಗೆ
precipitated
ಬರ್ಲಿ.
steps, my lords.
ನೀವು
That's it.
ಎಲ್ಲಿದ್ದೀರಾ ಅಂತ ಹೇಳಿ. We'll protect the liberty. Yes.
My lords, this petition may be tagged along to this petition.
No, no.
my lords. It's a
Accused
arising
number
out
one
of
ಅಲ್ವಾ?
the
Tag ಮಾಡೋಣ ಕೊಡಿ.
same crime number, my lords.
We'll post it day after tomorrow.
Let it be that, please, my lord, I just bow down to your lordship, my lords. Let it be that no coercive
Don't,
step be
don't do
undertaken
anything.
against
Day after
them, my
tomorrow
lords.
we'll answer everything.
I will not take it.
Stop interfering in property disputes. Stop interfering in civil cases. ಇಲ್ಲ ನಿಜವಾಗಿ ಎಲ್ಲೋ ಮರ್ಡರ್ ಆಗಿತ್ತೆ ಅಲ್ಲೋಗಿ ಹುಡುಕಿ ಹಿಡೀರಿ ಅಂತಂದ್ರೆ ಬರೀ ಸಿವಿಲ್ ಕೇಸ್ಗೆ ಎಂಟರ್ ಆಗ್ತೀರಾ. ಇಲ್ಲ 69 ಪ್ರಾಮಿಸ್ ಟು ಮ್ಯಾರಿ. ಅವ್ರೇನೋ ಪ್ರಾಮಿಸ್ ಮಾಡಿದ್ರೆ ನಿಮಗೆ ಏನ್ ಪ್ರಾಬ್ಲಮ್ ಪೊಲೀಸ್ನವ್ರಿಗೆ?
My lords, in fact, my lords, on the day of their
ಯು
atrocity,
ಸೋ ಇಂಟ್ರೆಸ್ಟೆಡ್ ಇನ್ ಪ್ರಾಮಿಸ್ ಟು ಮ್ಯಾರಿ.
ಅಲ್ಲಿ ಬಂದು ಸ್ಟೇಷನ್ ಕೂತ್ಕೊಂಡು ಧರಣಿ
ಸ್ಟೇಷನ್ ಅಲ್ಲಿ ಕೂತ್ಕೊಂಡು ಅಳ್ತಾ ಇರ್ತಾರೆ ಅಂದ್ರೆ ಕಳಿಸಿ ಆಚೆಗೆ. ಅದಕ್ಕೆ ಪ್ರಾಮಿಸ್ ಟು ಮ್ಯಾರಿ ಅವ್ರು ಮಾಡಿದ್ರೆ ಏನು, ನೀವು ಪ್ರಾಮಿಸ್ ಮಾಡ್ದಂಗೆ ಹೋಗಿ ಎಲ್ಲರನ್ನ ಅರೆಸ್ಟ್ ಮಾಡ್ಕೊಂಡ್ ಬಂದು ಗಲಾಟೆ ಮಾಡಿ. ಎಸ್, ದಿ ಪೆಟಿಷನರ್ is before the court. Only arrest or you challenge everything?
We've challenged everything. FIR.
The petitioner is before the court calling in question registration of a crime in crime number 586 of 2026 for offences punishable under section 61, 338 and 340 within bracket 2 of the BNS 2023. What drove the petitioner to this court was the police taking the accused number 2, a witness to a particular will which is pending adjudication before a competent civil court, into custody. A crime comes to be registered in crime number 586 of 2026 for the aforequoted offences. The petitioner is drawn as accused number 2. The jurisdictional police, i.e. the Whitefield subdivision police, issue a notice to the petitioner under section 35(3). The notice given on 25/8/2026 reads as follows. The notice directs the petitioner accused number 2 to appear before the Whitefield Police Station for the purpose of investigation at 11 a.m. on bold element 27/8/2026, 2 days after the issuance of notice. This is the unequivocal chain in the notice. The police pick up the petitioner from his house by arresting him 2 days prior to the date on which he was directed to appear. The 35(3) notice is also said to have been issued by the police at the house of the petitioner at the time when he was taken into custody. Be that submission as it is, but the notice itself indicated that the petitioner was to appear before the Whitefield Police Station on 27/8/2026 at 11 a.m. but is taken into custody 48 hours even before his appearance, even before the time that he was asked to appear. It is trite law that once the police set the procedural law into motion by issuance of a notice under section 35(3), the arrest of a person or the noticee can be only if the said person would display non-cooperation with the investigation. It is only then he can be taken into custody if a notice is issued under 35(3) and he is directed to appear and on his appearance would not cooperate with the investigation. That time had yet to arrive, as it was 48, there was 48 hours time for the petitioner to appear before the police and cooperate with the investigation. The petitioner is then taken into custody in the morning of 25/8/2026, produced before the learned magistrate at about 3 p.m. It is then the matter was moved to be taken up immediately, as the arrest was on the face of it illegal. This court passed the following order on 25/8/2026. The petitioner was not then remanded to judicial custody, but was set free by the concerned court owing to the interim order granted by this court. Nonetheless, the petitioner was arrested and was produced before the learned magistrate for the purpose of remand to the judicial custody or otherwise. It is the submission of the learned counsel for the petitioner Angat Kamath stands to reason for all the nuances of an arrest is followed by the respondent, and while he was produced before the magistrate for an order of seeking remand to judicial custody by filing a remand application.
I've been told, my lord, he was taken to magistrate, but not produced before magistrate based on this order.
Based on the order. Anyway,
ಮಾಡಿದ್ದಾರೆ.
remand application. Arrest ಅಂತ ಮಾಡಿದಾರಲ್ಲ.
Affidavit
Yes. So and so. The action of the investigating officer is on the face of it in blatant violation of the law laid down by the apex court in Satyendra Kumar Entil 2026 2 SCC page 162, where the apex court holds as follows. The apex court holds that once the procedural law is set into motion by issuance of a notice under 35(3) or 41A of the CRPC, the statutory predecessor of the BNSS, the only circumstance that one can be taken into custody is on display of a non-cooperation by the accused. The time was yet to arrive, but the liberty of the petitioner was taken away by his arrest by the police, the investigating officer who is present before the court and has no answer as to why he was taken into custody, whether he was pressurized by his official superiors or otherwise. There is no answer to any query of this court as to why the procedure as stipulated in law by the judgment of the apex court supra was not even noticed by the investigating officer or his superiors in the said police station. It is not only the investigating officer who would be responsible for this atrocious act on their part of taking the liberty of a citizen for granted and taking him into custody. The entire police station is equally responsible. The officer in charge of the police station or the superiors who man the police station, the assistant commissioner of police, or the Deputy Commissioner of Police who have just let the investigating officer to behave in a manner that is blatantly contrary to law. They are equally responsible on their supervisory dereliction. The learned SPP, though, would put up vehement defense on in an aid to protect the investigating officer who has on the face of it fumbled in law by arresting a person who could not have been taken into custody once the notice was already issued. Therefore, it is not a case where this court would show hands off to such attitude of the investigating officer, but mulct the investigating officer with exemplary costs apart from a direction to initiate departmental inquiry against the investigating officer and the official superiors who have permitted the investigating officer for their dereliction of supervisory roles. Therefore, the arrest of the petitioner, which on the face of it is illegal, is declared as such, and the investigating officer is now mulcted with cost of rupees 5 laksha, 10 laksha from his salary, sir. Not from his pocket, it has to go, not from the state exchequer. The cost of such illegal arrest is quantified at 3 lakhs to be paid by the investigating officer, by the official superiors who have shown dereliction of supervisory duty upon the investigating officer. The amount of cost that is to be paid to the petitioner shall not be from the state exchequer, as it is public money. Since the investigating officer has acted contrary to law, the cost shall be paid from his pocket, or the cost shall be paid from the pockets of those who man the police station, i.e. the Whitefield Police Station.
The Karnataka High Court strongly criticized the Whitefield Police over arrest of a man who was allegedly only an attesting witness to a disputed will. The court noted that police had already served him a Section 35(3) notice, asking him to appear at police station on August 27 at 11 am. Yet instead of waiting for him to appear, police allegedly picked him up from his house and arrested him nearly 48 hours earlier. The judge questioned the investigating officer about the reason for the arrest and whether any senior officer had pressured him to take the step. The court observed that arrest was prima facie illegal and said responsibility could not simply be placed on one officer, as the police hierarchy could not escape accountability. The court imposed ₹3 lakhs in costs, directing that the amount be recovered from the salaries of the officers responsible rather than from the public exchequer. It also ordered a departmental inquiry and stayed further investigation against the petitioner, while making it clear that the stay would not apply to accused number 1.